The invitees to come to the stage. May I invite Professor Kumud to come onto the stage, Professor Renu, Professor Vasanthi, and Justice Muralidhar. Renu, the last. Be careful. Sorry. Go there. Good afternoon, everyone, and some more guests will join, but at late time, so we are starting. Today, we are going to have the 30th J.P.Naik lecture, organized by Center for Women's Development Studies. The J.P.Naik Memorial Lecture has been there for the 30 years together, and we have his picture also kept here. J.P.Naik is an educationist and a renowned scholar who had concerns over the issues of those contexts also, illiteracy, dropout, women's development, the inclusion of the disadvantaged or deprived section. And he strongly believed that education is the pathway for social justice, self-reliance, women's development, and also economic growth. And he did advocate that the social scientists, when they are taking up research and whenever they point to the flaws of the development projects, etc., they should also go for assessing the reasons for failure and produce strategies for the success also. That was his advocacy for the social scientist. And he was very much instrumental in initiating this center with a small grant in the beginning from Vikram Sarabhai Foundation, and then later to Autonomous Center with the support of ICSSR. So then onwards, we have been working, and we now have, though there were 30 years of different memorial lecture, this is very important in the context in which we are there. The topic also, that is the 50 years of towards equality. We are going to have our speaker reflecting on that very much, and we are looking forward as to what are the areas which need to introspect and then revisit. We do have a series of other programs also with CWDS to have regional workshops and also national conferences that will be happening in the entire year together. And this is a beginning, that this memorial lecture is the beginning, and thanks to Professor Vasanthi for inviting Justice Muralidhar to be the guest speaker today. And of course, this towards equality, 50 years now, there were a lot of changes, and the context in which we started and now are, there are a number of progress on the one hand, and also there are issues. Anyway, but we all know, at least in women's studies, we take this towards equality report as the I should say a Bible for us, and it laid foundation to understand the gender perspective in which the issues to be viewed. And so it laid foundation for women's movement in the independent India, and pointed out or underlined the very important and core issues of the discriminatory areas, right from the sex ratio, the declining sex ratio, to the other issues in terms of gender disparities in the life history, death rates, etc. and of course access to livelihood, education, literacy as far as the women are concerned. And this report also campaigned for or advocated for kind of involving yourself in legal awareness, crashes, provision of crashes, and better conditions of work, and of course the law reforms on various areas like inheritance, maintenance, adoption, etc. As far as the focus of the report is concerned, there were three important areas which we need to. It was concerned with women and gender issues on the one hand, and also advocated or based on the kind of issues we have to work on that, develop tools and concepts to facilitate collection of data and deeper analysis in a gender perspective, and also setting of policy and planning and national machinery to work and represent women and gender concerns. So the journey over these 50 years has been mixed, and since 90s where the neoliberal policies have been initiated, we are really into kind of the both patriarchy and capitalism operating together to put democracy in stake, and also deepening the social and gender inequalities. So this is one context where we have to discuss and dwell upon. And people who were earlier associated with the Committee on Status of Women in India, who produced this report, were also, those would also be the member of Center for Women's Development Studies, right from Professor Veena Mazumdar, Bulreno Guha. They were respectively the member secretary, and the chairs also continued here as director and chair of Center for Women's Studies. So that way, that has a legacy to continue. Whatever has been discussed there could also be carried forward. And of course, we had Professor Lotika Sarkar, Leela Dubey, Sakina Hassan, and of course our own Professor Kumud Sharma. So now we have Kumud Sharma, who was associated with the drafting of the report as a research associate, present here, who will be chairing the session. And then onwards, CWDS has been engaging in undertaking, generating and promoting primary and applied research on various issues of concern to advance women in politics and nation building. And in this, with this few words, I would like to welcome our speaker, Justice S.Muralidhar, who really agreed to be the speaker for this important issue of concern, particularly the 50 years of Towards Equality report of Committee on Status of Women in India. And we have Professor Vasanthi, the chair, who will be doing the opening remarks, and Professor Kumud would be chairing the session, and Renu, who will be here to propose vote of thanks. As far as before closing, I should also introduce the speaker. I welcome the speakers, speaker and others there on the stage, and also others who have responded to this invitation and being here. And it would definitely be a kind of a rich discussion given the composition of the participants here. Justice S.Muralidhar did his education, particularly in the early years, there in Chennai. I am happy to introduce him. He had his chemistry graduation from Chennai and moved to Bachelor of Law in the University of Madras in '84. And he has been a very leading student, stood first rank there. And he moved to Nagpur University in '90 to do his LLM. And there again he stood, secured first rank. And he got this PhD awarded from Delhi University in 2003, and he is the proud student of Dr. Lotika Sarkar. His topic was on legal aid and criminal justice system in India. He began his law practice in Chennai in 1984 and moved to Delhi in 1987, and then onwards he was associated, and early Earlier, he was practicing the Supreme Court and High Court of Delhi for 2 decades together. And then he held many capacities. He was an advocate on advocate on record in the Supreme Court of India. He conducted several pro bono and PIL cases. He was active as a lawyer for the Supreme Court, Legal Services Committee, and counsel for the Election Commission of India, National Human Rights Commission, and the part-time member of Law Commission of India. He was also appointed as a judge of High Court of Delhi in May 2006, and later became Chief Justice of High Court of Orissa in January 21, and retired in August 2023 recently. And if you go through his the judgment and the PILs where he delivered judgments, to propaganda definitely that he was for the marginalized and of course for the women also. A couple of judgment where one was dealing with the reproductive health needs and how the pregnant women failed to access to the schemes, government schemes. He was very much saying that it is right, health is a right for women, that to particular for pregnant women, and no one or nothing could stay as a barrier. So that was the one. There one also important on the resettlement of the hatmaids for the poor, wherein they were denied the basic amenities, wherein the judgment was very much underlining that it is a right, housing is a right or a shelter right. It should go, whatever you provide, it should be endowed with the facilities, the basic facilities. So all the other whatever judgment he delivered also very much propaganda that he is working for the marginalized and the rights and right-based approaches. And later, as a Chief Justice of Orissa, High Court of Orissa, he spearheaded several reforms. Particularly, one was about the administrative reforms in digitizing the records of the court, which is very challenging because now we can access to the records if it is digitized. So that was one of his major contributions. And also set up the Center for Judicial Archives and the Museum of Justice in Cuttack. And on October 17th, he was again designated as a senior advocate and by the Supreme Court of India, and has returned to his practice. So such a renowned person is here, and I'm happy to welcome you again. And I invite Ms. Neeru to welcome him with a bouquet. Neeru, please. So once again, I welcome all of you for responding to the invitation, and I now hand it over to Professor Kumuth to conduct the session. Thank you.
Thank you, Mani. I thought since you have asked me to come to have a few thoughts of my before I invite Justice Murali to speak on the main theme. I believe that towards equality, or the report of the Committee on the Status of Women in India, it was a watershed moment for revival of the debate on women's issues. In a way, towards equality provided an impulse or a basic frame of reference to, it reframed several questions, and I think you have referred to them. Also, it sort of had a closer look at many of the issues which were highlighted and for years they were debated, which was declining sex ratio, work participation rate, negligible representation of women in elected bodies, the whole question of plurality of personal laws and how they affect women, etc., etc. But I feel that the timing of the report has some significance because A, it coincided with the International Women's Year or the first UN Decade for Women. And I think because at that time, both the global and national debates were taking place, it became a reference document for many. It also sort of started fresh debates on some of the issues that was flagged by the committee. Secondly, it, I think, preceded the declaration of national emergency. And it was possible for those who were responsible for taking a permission from the then Prime Minister to place it before the Parliament. It was placed, it was debated by the Parliament, and then a national plan of action was drawn as a kind of a follow-up. So I think all this happened maybe a couple of months later. If it would have been submitted, maybe it may not have seen the light of the day. I think it was quite interesting that as a follow-up, an empowered committee was constituted by the government with no representation from the members of the CSWI. And it was all bureaucrats who processed the recommendations of the committee, and most of them were rejected, including need for a policy for women, need for mechanisms to set up to monitor the infringement of women's rights, etc. I think the third point which was there, that it marked the beginning of the new phase of the women's movement. I'm not saying that the women's movement was dormant, but it was there. But at that time, I think the report did sort of give impetus to women's movement. I think what also happened at that time was the institutionalization of women's studies as a discourse, as a discipline. And I think that is what the first sponsored program on women's studies was instituted by the Indian Council of Social Science Research. And I think later on, you see in the 80s, I think how women's studies entered the universities. The committee had two very clear mandates. One was to sort of analyze the changes in the status of women in the post-independence period, that is first 25 years. And the second was to examine constitutional, legal, and administrative provisions which have an impact on women's status. It's interesting that the committee did not critically examine the constitutional provisions which were relevant for women. And I quote that the committee argued that equality is an article of faith in the Indian Constitution. And so a committee has treated it as a kind of a settled issue. So no further discussion was necessary on that. It was also argued that since the Constitution speaks to women in so many voices, it was a very challenging terrain for the committee to explore it in its many complex ways. 20 years later, I think we had a meeting about 20 years after CSWI, and in that meeting, Latika Sarkar, who was a member of the committee, lamented the fact that why they did not critically examine some of the constitutional provisions which were relevant for women. It's interesting that she was not only a member of the committee, but she was also the coordinator of the legal task force of the committee. And then there, I think, the three members of that task force later on were also the signatories of the open letter to CJI after the Mathura case. And the same three members of that legal task force later on gave a memorandum to the Parliament asking them to recognize custodial rape. I think, I'm sure Murali is going to touch on all these things. What is interesting, that the then member secretary of ICSR, J.P.Naik, and whose memory this lecture has been instituted, he asked the committee to reopen the question of equality. But most of the members were opposed to this whole idea. And what happened later on, that even when the report was titled Towards Equality, some of the members had a strong opposition to the title. She said this equality is a settled matter in the Constitution. We have got equality, Why do we want to name it towards equality? So let us not, have this title. It's interesting tidbits which I remember from there. According to them, they had an abiding faith in the constitutional provisions of equality. I think this belief that we don't need to sort of again open the question, or we don't need to debate it, I think it also led to their opposition to the whole question of reservation of women in elected bodies. They said, if we accept the idea of gender equality, why are we asking for reservation? So I think they were totally opposed to this idea, and the two members, which is Beena Mazumdar and Latika Sarkar, they gave a dissent note, and they said that there really is a sorry state of affairs that we have lost a political perspective on the issue of women. I think it took about 2 decades of sustained campaign to have the 73rd, 74th Amendment passed in 1973 and 74. Later on, it took another 30 years for the government to pass the Women's Reservation Bill in 2023. I don't know, I may say, what motivated them to rush through the bill. Perhaps the greater turnout of women voters in the elections might have forced the shift. We have seen that over the years, I think Mani has also talked about, that we have seen several initiatives, whether it's setting up mechanisms like National Commission on Women, declaration of a national policy, and changes in research in, I think, within the university system. The women's studies also has made a place for itself and has questioned, many of the established academic norms. But there is a systemic denial of women's rights, which is why, despite the fact that there have been many changes, and I don't want to go into the details, but the very fact that today's changed socio-political scenario, I think, has thrown many challenges. And many of us who have been analyzing what is happening around today see that we have seen contradictory trends in the society. But on the one hand, the current narrative of Nari Shakti or women's empowerment is very much part of the debate. But at the same time, you also see the rising violence and crime against women. The divisive identity politics today, which is dominating the scenario, has it eclipsed the struggle for equality and justice for women? It's a question which can be raised about that. Also, I think the restructured academic spaces. Today, I think a lot of changes are coming there, where emphasis is more about that if you want to become $3 trillion economy, or the third most, third economy in the world, then perhaps the emphasis is more on economic growth, GDPs, and all that, rather than in terms of seeing that what is happening to the different sections of the society. The challenge also lies in the notion of how notions of equality and justice are negotiated by those who are the disadvantaged section, including women. Are there spaces available to women? And if so, then how they are engaging with various systems, political, social, cultural, economic. Are we moving towards equality as this report signifies? Or is it that most of the time it's a matter of academic debates? I hand over to Professor Murali to give his lecture.
Oh, go ahead. Go ahead. It's okay. We want to hear you.
No, that's okay. Well, I want to hear you.
Well, some other time maybe, because there's shortage of time then.
All right. I'm going to use some of this space. A very warm good afternoon to everyone here. Professor Mani Meghale, Dr. Kumar Sharma, Professor Vasanthi Raman, all the distinguished members of the audience. I know I've taken on a daunting task, but I'm going to give it a go. It's an honor to be invited to deliver the 30th J.P.Naik Memorial Lecture. The event honors the memory of India's well-known educationists, who was awarded the Padma Bhushan in 1974. Mr. Naik shared a birthday with Dr. Radhakrishnan, and on 5th September 2007, a commemorative stamp was issued in his honor by the Indian government. His name finds mention in UNESCO's roll of honor of 100 educational thinkers of the last 25 centuries. Mr. Naik was one of the moving spirits behind CWDS and a great support. In the afterlife of the report of the Committee for the Status of Women in India, he played a very significant role. I'll mention that later on in this lecture. This lecture series itself has an illustrious record of eminent speakers, with Bharat Ratna Dr. M.S. Swaminathan inaugurating it in 1982. The 15th lecture, titled Memory and Rightlessness, was delivered by Professor Upendra Bakshi, in which he says that he learned from Professor Naik, and I'm quoting Professor Bakshi, at least 6 difficult virtues: the need to innovate institutions, practice vigilance over details, exact austerity in institutional expenditure, develop ability to relate to interdisciplinary traditions of communication, find the 25th hour every day, and achieve directness in conversation that at the same time did not offend other people. Very tall order indeed. I'm doubly honored to be asked to deliver this lecture in the honor of such a person. The choice of the topic was an obvious one, given the passing of 5 decades since the committees, the Committee on Social Study of Women in India, Status of Women in India, submitted its report titled Towards Equality. The report was submitted under cover of a letter dated 31st December 1974, addressed to Professor Nurul Hasan, then Minister for Education and Social Welfare. It appears to have been actually handed over on 1st January 1975, which, as Professor Mani Megale mentioned, was the first ever UN International Women's Year. The report was unprecedented and historic. I therefore thought it but natural to discuss the report and its aftermath and give a nudge for a similar exercise on perhaps even a larger scale. Given that 2 members of the committee, Dr. Lutika Sarkar and Dr. Veena Majumdar, who was also the member secretary of the committee, were the founding members of the CWDS, it is perhaps appropriate that the push for a similar renewed initiative comes from the CWDS, and I'm happy to know from Professor Mani Megale that the good part of this year will be devoted to a series of talks and discussions hosted by the CWDS on such an exercise, on the possibility of such an exercise. In the first part of this talk, I briefly traced the background in which the committee was constituted, its terms of reference, its members, the methodology adopted by them, the major themes dealt with, and the recommendations made. I may be repeating what both Professor Mani Megale and Dr. Kumar Sharma have said. I request you to pardon me for that. I also note again briefly the impact the report has had in shaping the women's movement, the field of women's studies, and in triggering the changes in the law relating to women. For this part, the first part, the main source material was not just the report itself, but the 3-volume reprinted version brought out in 2012 by the CWDS, with an introduction to the series by Dr. Veena Majumdar, which is extremely enlightening, and another introduction to the report itself, Towards Equality, by Dr. Kumar Sharma, who incidentally, as was mentioned by Professor Mani Megale, was a research associate with the Committee on the Status of Women in India, and Srimati C.P. Sujaya, which explains how the committee came about sometime in the 1960s, soon after the declaration of the elimination of discrimination against women. By the early 1970s, Canada and UK had appointed royal commissions of inquiry, and the United States had appointed a presidential commission. As far as India is concerned, the starting point appears to have been a letter received by the Government of India from the United Nations with several reminders asking for a survey on the status of women. There was confusion as to which department of the Government of India should deal with this request. In a piece titled Looking Back 30 Years Since Towards Equality, Veena Majumdar, Latika Sarkar and Dr. Kumar Sharma explain how the letter landed up on the desk of the then Minister in charge of Social Welfare, Dr. Fulrenu Guha, who wrote a note pointing out that apart from the request, it was high time to review what had been happening to women in India since 1950, when the Constitution had pledged equality to all and all sections of society. She proposed the constitution of a commission of inquiry. By a Government of India resolution of 22nd September 1971, the Committee on Status of Women in India, with 9 members, was constituted, with Dr. Guha as chairperson, to undertake a comprehensive examination of the rights of women so that it would provide useful guidelines for the formulation of social policies. It would take another 2 years for the committee to be reconstituted, this time as an 11-member committee with Dr. Guha continuing as chairperson. The committee had some remarkable personalities as members. Maniben Kara, a trade union leader, Neera Dogra, chairperson of the Central Social Welfare Board, Urbila Haksar, writer with a background in labor law, welfare, education and international relations, 2 members of parliament, Savitri Shyam and Vikram Mahajan. Incidentally, Vikram Mahajan was the only male member. And 4 academics, Latika Sarkar in the field of law, Sakina Hassan in the field of literature, Leela Dubey, social anthropology, and Veena Majumdar herself in the field of political science. The terms of reference of the committee, which again has been adverted to both the speakers earlier, and as paraphrased in its reports, were threefold. A, to assess the impact of the constitutional, legal, and administrative provisions on the social status of women, their education and employment, particularly in the rural sector in the last 2 decades. B, to examine the status of women in the changing social pattern. And C, to suggest remedial and other measures in the fields of law, education, employment, population policy, etc., which would enable women to play their full and proper role in building up the nation. There was no precedent for this kind of an exercise on a national scale. The committee took the assistance of task forces appointed by it, and incidentally, the legal task force had one of the signatories to the open letter, Dr. Kelkar, which included the task forces on education, economics, legal aspects, political aspects, social aspects, and employment. Then there were expert groups to advise the committee on issues such as dowry and health. Members of these task forces and expert groups included academicians and professionals across a range of disciplines. There were several appendices to the report. Appendix C gives details of the surveys conducted by the committee in 9 states. Appendix E, a list of 105 persons who were invited to Delhi for discussion. Then the committee undertook tours of 26 states and union territories. The list of people invited by them during the tours included voluntary and professional social workers, working women, agricultural laborers, village level workers, urban professionals, women in trade and business, women in political and public life, housewives in different economic groups, and women from minority in different communities. The list included officials from various departments. The tours happened over a period of 17 months. Appendix F lists 78 studies submitted to the committee. 4 of the members of the committee constituted the drafting committee. These were Dr. Guha herself, Dr. Sarkar, Dr. Majumdar, and Urbila Haksar. The committee gathered data from primary sources, including the census, the National Sample Survey, and regular publications of various agencies of the government. It also examined reports of various commissions and committees, not only the ones relating to women's education, but other investigative commissions on agricultural labor, unemployment, etc. For the survey, a structured questionnaire was prepared and mailed to voluntary organizations, women's colleges, institutions, institutes of social work, and departments of sociology, government state agencies, including state welfare boards, and some individuals and researchers. A total of 8,000 questionnaires in different regional languages came back for analysis and provided evidence of several major variations in the opinion of women and others in different generations, many of which were unexpected for the committee members. I must compliment one of the research associates who's sitting here, Dr. Kumar Sharma, for being part of such a massive exercise in an age when there were no computers, to just sift through 8,000 filled up questionnaires gathered from 26 states and so many persons must have been a very mammoth task, and hats off, and can we congratulate you for that? the issue was of conceptual clarity. What I found so rich about this committee, it was not ever meant to be a casual exercise. It could not be a casual exercise. But the seriousness with which they approached the subject, they sifted through every word of the terms of reference. The title itself of their committee was Committee on the Status of Women in India. So early on, the committee recognized the need for conceptual clarity as to the task that was to measure the gaps that separated women's current roles and status from the requirements of their new roles that the Constitution and the accompanying framework expected of them. First, the committee dwelt on the expression status and noted that it was necessary to adopt a comparative approach, since in a purely sociological sense, status does not imply rank or hierarchy, but denotes only position vis-a-vis others in terms of rights and obligations. The committee noted, and I'm quoting, "A woman, like any person, occupies very many status positions at a given point in time and plays a number of roles, such as those in the kinship system, family system, and the wider social system. Her status in society is usually not determined by any one particular status position held by her, but by her composite status, which results from the merging of various status. To this should be added her consciousness of her own status." Kumud Sharma and Sujay observe that the committee realized that the yardstick to measure women's status and inequality had to be a qualitative one and therefore value-based. They had already so much data, but this is what weighed with them most. The deployment of disaggregation in looking at information on society in general and women in particular became an important priority for the committee throughout the report. The committee noted, and I'm quoting, "Our investigations persistently revealed the meaninglessness of national and state averages in determining the status of women in the context of gross inequalities. The answer may be in identifying the actual groups by social, economic status, or regional or communal origin." The committee noted that any meaningful analysis of restrictions imposed by social attitudes and norms, possession or lack of necessary equipment like education and other employable skills, political awareness, etc., was only possible by studying women in different categories. It observed, and I'm quoting again, "Our experience showed that while Indian society can be categorized by castes, communities, and classes, for our purpose, the most relevant broad categories were as follows. The first, women below the subsistence lines, whose problems and constraints are radically different in nature from those suffered by women in other sections of society. Second, women who move continuously between security and subsistence and often descend below the subsistence line with the disappearance of their means of earning a livelihood." I must point out here the Human Development Index reports, they have built around this. I mean, this was a forerunner for all of that, where they talk of vulnerable populations, how the vulnerable populations can slip below the poverty line and suffer greater disadvantages. And the third category, women firmly above the security line. Then there was the issue of clarity of the expression equality. While Professor Meghale was right that in para 1.37 the committee says this: "Equality is an article of faith in our constitution and guaranteed by specific articles. We could therefore treat this as a fact for which no discussion was necessary. Our investigation, however, proved that there was still considerable ambiguity as well as ambivalence in the general understanding of the need and implications of sex equality in our country." So they then develop in the next paragraph 1.38 this concept further. The committee believed that equality of women is necessary not merely on the grounds of social justice, but as a basic condition for social, economic, and political development of the nation. That in order to release women from their dependent and unequal status, there has to be improvement in their employment opportunities and earning power, and this has to be given the highest priority. That because of their childbearing function, the responsibility of safe bearing and rearing of children had to be shared by the mother, the father, and the society. That the contribution made to the running and management of a family by an active housewife should be admitted as economically and socially productive and contributing to the national savings and development. That marriage and motherhood should not become a disability in women's fulfilling their proper and full role in the task of national development. It was important that society, including women themselves, must accept their responsibility in this field. Importantly, the committee recognized that given the disabilities and inequalities suffered by large sections of the population under the operation of an exploitative system, it was important for the emancipation and development of women to form part of the total movement for removal of inequalities and oppressive social institutions. Lastly, if the society was to move in the direction of the goal set by the Constitution, then special temporary measures would be necessary to transform de jure into de facto equality. You can see how this gives a conceptual framework for later scholars to come and develop further on this, particularly its de jure and de facto, or what we say substantive equality. The committee realized the meaninglessness of bifurcating political and economic rights. And I must say these were in very early years, because India was had ratified both the ICCPR and the ICESCR. And yet there was not much discussion on the implications of all of this. The committee realized the meaninglessness of bifurcating political and economic rights, that political rights were only instrumental for achieving gender equality of status and opportunity, and that there was a unity between political, economic, and social issues was forcefully brought to the committee during their travels and interactions with the public. And I'm quoting from the committee's report. It has been argued that political equality is meaningless in a country where the mass of the population suffers from poverty. This actually echoes Dr. Ambedkar in the Constituent Assembly. Continuous threat of starvation, illiteracy, lack of health, and inequality of class, status, and power. It is more so in the case of women who suffer from another dimension of inequality, namely the weight of traditional attitudes that regards them as inferior to men. And this word attitudes is a running theme of the entire report. It is, however, clear from Mahatma Gandhi's statement that the equal legal and political rights of women were only to be a starting point to enable the society to transform itself, a process in which women would be the prime movers. The report dwelt extensively on the attitudes towards women and was damning in its indictment that, and I'm quoting, all the indicators of participation, attitudes, and impact come up with the same results. Namely, though women do not numerically constitute a minority, they are beginning to acquire the features of a minority community by three recognized dimensions: economic situation, social position, and political power. If this trend is allowed to continue, the large masses of women in India may well emerge as the only surviving minority continuously exposed to injustice. Now I move to the recommendations made by the committee. The report was the first of its kind in the country. Till then, the earlier publications that had references to women were grounded in the social welfare format. The report shifted the lens from seeing women akin to social categories of handicapped, vulnerable, and victim women to seeing the problems of women across socio-economic categories. The report had a separate chapter on women and the economy. Demography was another separate chapter. This was the first committee to study women and their situation at the national level. It was a trendsetter in looking at women in totality. Also, it gave a clear signal to the state that in view of its constitutional obligations, the state had a major role to play. The report towards equality pointed to the tardiness on the part of the government to use Article 15, Subarticle 3 to bridge the chasm between a new social order proclaimed by the Constitution and the realities of contemporary Indian society as far as women's rights are concerned. It noted in anguish, and I'm quoting, that in spite of the special powers provided by Article 15.3, almost no efforts have been made to address the unequal status of women in different spheres. Of the many recommendations made by the committee was the establishment of an exclusive department in government to deal with all of women's issues, the setting up of a national commission for women at the center and the states to collect information on different aspects, namely education, employment, health, welfare, political participation, impact of social legislation, and so on. The function of the commission would be the evaluation of existing policies, programs, the laws that have a bearing on the status of women, with powers to censure non-implementation of the measures, point out deficiencies in such measures, and suggest amendments and improvements. I think if you now look at the reports of the NCW, you will know how far they are from doing all of this. What is interesting is, I think the last 3 issues of the NCW makes it a point to have the Prime Minister's photograph right prominently on the cover. The third function would be to recommend new laws, policies, and programs. Lastly, the Commission should be empowered to take effective steps to address grievances of parties affected by actual violation of existing laws. We'll show you some slides on this. There were detailed recommendations in regard to the social cultural setting of women's status. In the chapter titled Women and the Law, and Dr. Sarkar was the moving force behind this, there were recommendations regarding eradication of polygamy in Muslim law, enforcement of the provision against bigamy in Hindu law, registration of marriages, prevention of dowry, improvement in the laws of divorce, mutual consent to be a ground for divorce in all personal laws, parity of grounds for divorce for both husband and the wife. There were recommendations in regard to inheritance, matrimonial property, family courts. As regards the Uniform Civil Code, its absence was described as an incongruity, which cannot be justified with all the emphasis that is placed on secularism, science, and modernization. This is 1974. As regards age of consent, the report recommended that consent to have sexual intercourse requires more maturity than to have an abortion. The same age limit should be applied in both cases. It recommended amendments to the Better Benefit Act, equalization of wages, educational development, political status, and so on. I mean, it's a long list, so I'm not going through the entire gamut of recommendations. Then we come to the dissent note referred to both the previous speakers. Many of us know that in the committee, notes were given on various topics. Not all of the members agreed on everything, even though they were all good friends. When Dr. Upendra Bakshi was consulted by the committee, he had a different point of view on women's representation in legislative assemblies and parliament. So on representation, there were divergences of view only as regards representation of women in legislative assemblies and parliament, and there was unanimity as far as representation of women in panchayat bodies and local bodies was concerned. Three other social scientists were Iqbal Narayan, V.M. Sirsikar, and Lalit Sen. They also supported the idea of reservations in all legislative bodies. However, while the majority members of the committee agreed on giving women's representation in local bodies and panchayats, they did not agree to giving representation of women in legislative assemblies and the parliament. Dr. Sarkar and Dr. Majumdar disagreed from the majority in this issue. An extract from their dissenting note, which captures their position, reads as follows. And I'm going to read it a bit slowly because it's very significant. When one applies the principles of democracy to a society characterized by tremendous inequalities, such special protections are only spearheads to pierce through the barriers of inequality. An unattainable goal is as meaningless as a right that cannot be exercised. Equality of opportunities cannot be achieved in the face of the tremendous disabilities and obstacles which the social system imposes on all those sections whom traditional India treated as second-class or even third-class citizens. Our investigations have proved that the application of the theoretical principle of equality in the context of unequal situations only intensifies inequalities, because equality in such situations merely means privileges for those who have them already and not for those who need them. There's so much conceptual clarity in this one paragraph. You can read it again and again, anytime, any number of, in any number of generations. Veena Majumdar, in a piece written in 1999, explained how, and I'm quoting, for Lotika Sarkar and myself, taking this stand represented an enormous ideological and conceptual shift, and it was to develop into a search for a new identity for ourselves in the maelstrom of the politics of nation building. As daughters of independence, we had been critics of the special representation or class representation as a legacy of the colonial period, which sought to institutionalize backwardness of certain sections. Dr. Majumdar added, we found our understanding of nation building changing radically as we sought to come closer to the life experiences, the unacknowledged wisdom and knowledge, the priorities and perspectives of poor peasant and working women in the informal sector across the country and the subcontinent, forcing us to raise questions about the meaning of development, of freedom, traditions, modernization, social progress, and the dynamics of economic, cultural, and demographic changes that we had never asked before. A very candid admission of their own changing perspectives through the work of the committee. The report also pointed to the failures of society in general in realizing the constitutional mandate. To quote Dr. Majumdar, the committee, while criticizing the failures of the Indian state and important subsystems of society, did not make the mistake of underestimating the enormity of the responsibility shouldered by the post-independence nation. The investigation itself had exposed the appalling gaps in information, understanding, or capacity to give social space and shape to the constitutional mandate, not only within the state structures, but also within women's organizations, political parties, educational, and other social processes. This is the ability to think objectively, look 360 degrees, and see where all inequality manifested itself. The other thing which we may not be aware of is that the committee found that there were certain myths about the status of women in the country. As pointed out by Dr. Majumdar, these myths were demolished when the committee members met women around the country. I wish to highlight these myths. The first is that Indian culture and traditions do not permit women to work for a living. The committee found that the women had always been involved in significant economic sectors. The impact of transition to a modern economy contributed to the exclusion of women from active participation in the productive process. In fact, Dr. Majumdar lamented later that they did not have enough data to clearly expostulate this, what they were saying. According to the committee, with increasing mechanization, many processes of production that women were closely involved which were rendered obsolete, and there was a persistent unwillingness in the managements of industries to train women in skills for handling advanced machinery. The second myth that was demolished, that Hindu society does not traditionally permit divorce and women's remarriage. The committee, in a subsection on Hindu law, considered customary forms of divorce. It concluded that, and I'm quoting, contrary to the general notion of regarding the indissolubility of Hindu marriages, a large section of Hindus among the lower castes have traditionally practiced divorce. These customary forms of divorce were recognized both judicially and socially. Third, the third myth that was demolished, that dowry is a practice deeply rooted in the traditional culture and would disappear with the spread of education. I think people will recall that Dr. Sarkar, Madhumera was sitting here and Usha Ramanathan was sitting here, co-authored a study where they had to study the Dowry Prohibition Act's failures and the passing of the Dowry Prohibition Act. And they pointed out how G.S. Pathak, one of the strong opponents of passing of the Dowry Prohibition Act. G.S. Pathak was a senior lawyer, a very renowned senior lawyer whose son became the Chief Justice of India, and he was from Allahabad. And he argued in Parliament that if I wish to send my son-in-law abroad, who can stop me from doing it? So anyway, despite all those objections, the law was passed. That it has been a failure in implementation is another story altogether. The committee, based on its stores across all states of the country, found that there was no evidence that greater economic freedom, education and jobs for women contributed to rousing social conscience against dowry. The committee concluded that the process for dowry to disappear with the spread of education and increased job opportunities for women, given existing economic conditions, would be a very long one. The committee was in effect questioning the broad assumption that the increase in education and awareness would have the positive effect in the reduction in the instances of dowry harassment. The committee's findings in this regard continue to be relevant. Interestingly, even though South Delhi has a literacy rate of 86.5%, it continues to feature in the top 3 districts of the national capital of Delhi with a low sex ratio. The fourth myth that was demolished, that uneducated women's backward consciousness kept them away from political participation. The Committee on Examining Data on the Number of Women Voters in Lok Sabha elections from 1962 to 1971 noted that the relationship of political behavior with any single factor could not be generalized, and that patterns of political behavior varied across regions. On analyzing the political parties' manifestos and their nomination of candidates for the Lok Sabha elections in 1962, 1967, and 1971, the committee found that it was the structures of political parties that was male-dominated and possibly precluded them politically participating. If only the 2 judges who wrote the Rajbala of the state of Haryana had access to the committee's report, the entire basis of that judgment is that a woman who is not matriculated is somehow not eligible to become a sarpanch of a village. And it's one judgment which definitely requires to be revisited and overruled. Contrast this with the report of the committee comprising women at the top of their respective disciplines, telling the country that this is a myth. I just want to share the quote, what Supreme Court says in justifying this provision. It is only education which gives a human being the power to discriminate between right and wrong, good and bad. Therefore, prescription of an educational qualification is not irrelevant for the better administration of the panchayats. The classification in our view cannot be said to be either based on no intelligible differentia, unreasonable, or without a reasonable nexus with the object sought to be achieved. And I also wish to quote Aruna Roy, who keeps telling us about Naurati Devi, the Dalit woman in Rajasthan, who, very strong in her conviction, is a sarpanch and has made huge difference to the entire community, not just to Dalits in the village. Dr. Veena Majumdar, recalling experience in the committee, says, and I quote, "In Nagaland, I remember Lotikadi asking, 'Can you tell me what is this development all about? Who's more developed, the educated women whom we met yesterday or the village women we met today?' The report was tabled in Parliament in February 1975, debated for a full day, and a resolution adopted urging the Prime Minister to initiate a comprehensive program of legislative and administrative measures aimed at removing, as far as possible, typical bureaucracies, the economic and social injustices, disabilities and discriminations to which Indian women continue to be subjected." As the Empowered Committee, again this was mentioned by both of them, as the Empowered Committee comprising bureaucrats of the Government of India was set up, it completed its task in December 1976. It accepted just 20 of the 52 recommendations, and 13 of the recommendations were rejected outright, especially those falling in the realm of personal laws. As again already mentioned, the Empowered Committee was heavily male dominated, with all those in the senior positions, joint secretary upwards, they were all male. The only women were all deputy secretaries or section officers or superintendents. Among the few men who played a major role in shepherding the report through the entire pre- and post-emergency phases were J.P.Naik, who was then Secretary of the ICSSR, and Professor Nurul Hasan, the then Minister of Education. The report is stated to have made visible the hitherto unorganized women labor force, and yet it was not until 1987 that the Rajiv Gandhi government set up the National Commission on Self-Employed Women and Women in the Informal Sector. The report Towards Equality provided a benchmark for future research and studies on women's issues. ICSSR's program of women's studies was a pioneering effort to institutionalize women's studies in India. I think Dr. Majumdar moved on to the ICSSR, and you moved on.
She went back to UGC and was asked to join on deputation.
Right. And she set up a whole wing in the ICSSR on women's studies.
A unit.
Right. In the mid-1980s, the UGC decided to institute a program of women's studies in Indian universities. In 1988, the core group constituted by the Rajiv Gandhi government came out with the draft National Perspective Plan for Women, which contained a chapter recommending 30% reservations for women in all representative bodies from the panchayats to the parliament. All this led to the 73rd and 74th amendments to the constitution, which has been referred to. The National Commission for Women was finally set up in 1992. Can I just have that? In the Human Development Report brought out by the UNDP in 2022, titled Uncertain Times, Unsettled Lives, Shaping Our Future in a Transforming World, the authors explain in the introduction, and I'm quoting, "Layers of uncertainty are stacking up and interacting to unsettle our lives in unprecedented ways. People have faced diseases, wars, and environmental disruptions before, but the confluence of destabilizing planetary pressures with growing inequalities, sweeping societal transformations to ease those pressures, and widespread polarization present new, complex, interacting sources of uncertainty for the world and everyone in it. That is the new normal." Unquote. Political instability, persecution of ethnic and religious minorities, resulting large-scale internal displacement, and cross-border migration are adding to the pressures and stresses of human lives. The war in Ukraine and now in Gaza are but the most recent of the crises that have contributed to the furthering global instability and strife. The Human Development Report states how the world over, the HDI has dropped consecutively in the last 2 years. The HDI is a summary measure for assessing long-term progress in 3 basic dimensions of human development: a long and healthy life, access to knowledge, and a decent standard of living. The HD report, the Human Development Report, enumerates a series of factors that explain the contemporary and historical contexts that has resulted in this drop in the HDI values. The Human Development Report also highlights the growing inequality in society and continued gender disparity in the areas of education, employment, participation in politics. India's HDI rank in 2021 was 131 out of 191 countries. Interestingly, I saw one of those television clips where the minister is waxing eloquent on how the World Bank ranking India has progressed. And when he's faced with the question, but how come this report you accept and all other international reports you reject? This is stoic silence. India's Gender Development Index score was 0.849, which was lesser than the average of developing countries, for whom the average was 0.937, and also South Asia. For 2021, the HDI value for women was lower than that of men. Life expectancy for females was more than men. Expected years of schooling was also more for females than for men. But the estimated gross national income per capita was significantly lower for females than men. For Indian females, this number was lower than that of other developing countries as well as entire South Asia. There's also what is called the Gender Inequality Index. India's rank on this index was 122, with a maternal mortality ratio of 133 deaths per 100,000 live births, which was much positively lower than that of developing countries. The Gender Inequality Index noted that 13.4% seats in parliament were held by women, which was lower than the average for South Asia. In terms of labor force participation, the inequality was stark, as only 19.2% women aged 15 and older participated in labor, while the number was 70.1% for men. And this was lower than the average for South Asia and also the least developed countries. Then there is the Gender Social Norms Index, GSNI. This is the impact of social beliefs on gender equality across 4 dimensions: political, educational, economic, and physical integrity. Drawing upon data from 91 countries, it measures the percentage of people with at least one bias. The index ranges from 0 to 1. Higher GNI values indicate higher bias against gender equality and women's empowerment. For India, this value stood at 99.2 out of 100, the lowest value being 20. We have a more recent Human Development Report, which is titled Managing Interdependence in a Polarized World. And this sentence definitely caught my attention. It mentions the emerging democracy paradox. Nearly 9 in 10 people believe that democracy is a fundamental pillar of political systems, but support for leaders who may bypass the fundamental rules of the democratic process has markedly increased. Today, more than half of those polled express support for such leaders. And I would add, it's the launch of the new Bhakti movement. As regards the World Hunger Report for 2023, India ranks 111 out of 125 countries. With a score of 28.7 in the 2023 Global Hunger Index, India has a level of hunger that is serious. This report notes that in many parts of the world, young people are more likely than adults to be affected by extreme poverty and food insecurity, with young women particularly affected, despite the importance of the health and nutrition status for future generations. Young people are 3 times more likely to be unemployed. They often lack access to the resources, land, skills, and opportunities that would enable them to proactively engage in food systems. These barriers, as well as the challenges of climate change, land degradation, exposure to risk, difficult to precarious working conditions, and low social recognition, have turned many young people away from agriculture and rural livelihoods. Despite having ratified the Convention on Elimination of All Forms of Discrimination Against Women, CEDAW, India has been remiss in the submission of country reports, the last of which was in 2012. What is available in the public domain, and I'm open to being corrected on this, what is available in the public domain is a draft of the 6th periodic report, I don't know, Madhu, if what I'm saying is right, prepared by the National Law University of Delhi for submission to the CEDAW committee, in which there's a grudging admission regarding problems persisting despite the considerable steps being taken by the government, and this may be attributable to India's unique and varied socio-cultural dynamics, where the impact of outcomes may be exacerbated on account of intersectionalities between gender, religion, and caste, among the others. And now I turn to our present situation. Let us take stock of now what is happening around us. I was, in preparing for this lecture, Vansh has been helping me with this lecture, and I'm going to request him to step up, looking at the reports of the NCW and struck by the kind of complaints coming before it. Just want to show you some slides. and also the type of suo motu cases that NCW is taking up. Yeah, first we show you the 2021-22. So these are the complaints that NCW is regularly receiving. It doesn't tell us what it's doing with these complaints, but I'm surprised and struck, and I would like anyone in the audience to enlighten me on what is a complaint on the right to live with dignity and what does that actually mean, because it's the highest number of complaints, 11,127 in a single year. Protection against domestic violence, 6,460. Harassment of married women, dowry harassment, 4,512. Outraging modesty of women, molestation, 1,782. Rape, attempt to rape, 1,606. Police apathy against women, cyber crime against women, sexual harassment, right to exercise choice in marriage, honor crimes, dowry death. So I'm still intrigued what this right to live with dignity, which obviously is a category they have thought up, what does that mean? The National Commission for Women. Oh, I see. So Uttar Pradesh, I think it's covered by that. How do you get rid of this? Yeah. It's covering the whole thing. Anyway, so Uttar Pradesh is a very largely high number. Delhi, Maharashtra, Bihar, this is in descending order in terms of where they're getting complaints from. Now this is very interesting what I'm going to show you. This is NCW taking suo motu cognizance. All right.
Wherever they want.
But the kind of complaints which is even prepared to acknowledge, and it's getting, see, mob brands 4 women witches, and this is 2023, 22, and it's continuing even now. Minor inmate in a shelter home alleged sexual assault. Just imagine, Jaipur में हर दूसरे, उदयपुर में and जोधपुर में हर चौथे दिन बच्चियों के दुष्कर्म. Muzaffarnagar woman abducted, gang raped. Muzaffarnagar is also infamous for what happened in the children's institution for housing children. 2 booked for molesting women. This is the other thing. Hijab row, 6 girls' phone numbers shared on social media. So the entire gamut of the kind of crimes, you're getting a small sampling of it. Woman beaten up, her hair cut off over affair. Muslim women on sale. Website targets journalists, activists taken down after outrage. 21-22, yeah. Last is very telling. Dalit woman gang raped in Jewar, no arrests yet. And then when we look at 22-23, equally grim. And again you have this right to live with dignity. And I'm really intrigued about what this is, because year after year you're getting a large number of these complaints. Somebody should highlight, and I've searched the report and it doesn't give us any legend or. Uttar Pradesh has the highest number of complaints being sent to the NCW. A disproportionately high number, I would say. And Uttar Pradesh is touted as the safest for women. I know, but still I'm saying in comparison to, let's say, Madhya Pradesh, comparable states. That's all, yeah. No, they haven't. Actually, the report is very sketchy on what it's telling us, but somebody needs to get into it further and find out what this is all about. So this is the failure of the shelter homes, right? Auctioning of girls and stamp paper. Just imagine this. I just was thinking of the Kathua rape when the priest was a co-accused, and the BJP Mahila Morcha organized a protest against the arrest of the accused. Yes. Man strangles wife to death for refusing texts twice in the night. So that is the current situation as far as the NCW is concerned. I still have some more statistics to share. I'll just do it in a minute. I want to talk briefly about what this actually signifies. What all this is telling us is that despite a plethora of changes to the laws, the situation on the ground as far as women are concerned continues to be discouraging. Also, attitudes towards them, something that the report of the CSWI forcefully talks about. There has been a persistent failure in important areas of the law to act as an instrument of social change, be it the child marriage restraint law, the dowry prohibition law, the problem of witch hunting, the child labor law. Most recently, the Protection of Children from Sexual Offences Act, a penal statute to deal with child sexual abuse. The acquittal rates are perhaps the highest. The acquittal rates are as high as 99%. I'm just talking of the state of Orissa. Monetary compensation for rape victims has led to a different kind of misuse. The debate around the misuse of provisions like Section 498A has led to delegitimizing of the use of penal laws to deal with social problems. The woman victim gets further stigmatized and victimized in the process. The other development is that despite the rape law being made more stringent after the horrific gang rape in Delhi on 16 December 2012, there has been no palpable effect on the growing instances of rape around the country. In his book titled The Culture of Control, Crime and Social Order in Contemporary Society, Professor Garland says that last 3 decades of the 20th century witnessed a remarkable return of the victim to the center stage in a criminal justice policy. The earlier focus on the need to reintegrate the felon as an imperative of the public interest in treating no one, even the useless criminal, as dispensable, has given way to the interest and feelings of victims, actual victims, victims' families, potential victims, which are now routinely invoked to support measures for punitive segregation. There's an emergence of fear of crime as a prominent cultural theme. The next victim could be you. It could be your mother, partner, son, or daughter. The image of the delinquent as a misdirected person in need of attention has made way for legislation to stereotype the depictions of unruly youth, dangerous predators, and incorrigible career criminals. The background effect of policy is more frequently a collective anger and a righteous demand for retribution rather than a commitment to a just, socially engineered solution. And I'm quoting him, the emotional temperature of policy making has turned from cool to hot. In India, we are also faced with the robust resilience of the non-formal legal systems. The Khap and Katta Panchayats can still sentence Sagotra couples to death. A girl can be sentenced to gang rape because she decided to marry someone from outside her village. Women can be declared witches, be hunted down, lynched and burnt. Alleged child lifters, cow smugglers, even young thieves can be lynched. Bodies mutilated, acid thrown, faces blackened, women stripped and paraded. Those who kill for honor or commit gang rape during communal violence will be glorified. And yet there are some positive instances too. The Nari Adalats in Gujarat, the Muslim Women's Jamaat in Tamil Nadu, the Gulabi gang in Uttar Pradesh are inspiring stories of brave women who want to control their destinies. Another inspiring moment was when women manual scavengers or sanitation workers in the recent past in several states literally threw away their baskets and brooms to liberate themselves from the dehumanizing activity they've had to undertake generation after generation. This solemn act of self-emancipation had no state support and little society support. Then we have this phenomenon in all the high courts in the country, including Orissa, by the way. In the habeas corpus jurisdiction, our high courts are routinely visited by couples who had the courage to defy unjust societal norms, risk their lives, run away and seek protection. Some succeed and others don't, but they try. Some mindsets are liable to be changed, some not. I must share with you, and I've said this earlier, and sorry for repetition if some of you have listened to it earlier. I was sharing a session with some of the judges of the High Court of another state in the country, and we were exchanging notes on the what was happening in our high courts, and I was sharing with him that in the Delhi High Court, we routinely get these kind of habeas corpus petitions of runaway couples saying that please protect us from our respective parents. And I said on the side of caution, always grant them protection on the very first date, and then send notice to the parents. And till then, the SHO is asked to give them protection. And this judge turned to me and said, no, in Allahabad, I'm sorry, we don't do those things. I said, why? He said, no, the first thing which strikes my mind when such a petition comes is, if this were my daughter, what would I do? So then that told me that we come to the same issue from different ends. And these deep-held biases and prejudices do affect the way cases are decided. And yet, young women like Hadia are prepared to stand and fight for their choices. They today are shaping the law and guiding the courts to develop it in the vision of Ambedkar, who wondered if we would survive as a republic if we did not make equality and fraternity our constitutional creed. Hadia, as you know, had to again be dragged into court proceedings. Fortunately, the Kerala High Court this time around did not interfere. We all have heard of the open letter dated 16 September 1979, sent to the Chief Justice of India by 4 law professors, Dr. Upendra Bakshi, Dr. Kelkar, Dr. Lotika Sarkar, and Dr. Vasudha Dagavvar. And this was in the wake of the acquittal of 2 police women who were accused of gang rape of the victim in a police station. Now, what is important, and I'm sure all of you have heard this, that this letter, of course, was a trigger for changes in criminal law. There is a remarkable passage in the open letter which suggests that the members of the judiciary might want to reorient themselves to ground realities. And this is the suggestion the letter makes. I'm quoting it. There is not a single word condemning the very act of calling Mathura and detaining her at the police station in gross violation of the law of the land made by Parliament, and so recently reiterated by the Supreme Court. Nor is there a single word in the judgment condemning the use of the police station as a theatre of rape or submission to sexual intercourse. There is no direction to the administration to follow the law. There are no strictures of any kind. The court gives no consideration whatsoever to the socio-economic status, the lack of knowledge of legal rights, the age of the victim, lack of access to legal services, and the fear complex which haunts the poor and the exploited in the Indian police stations. May we respectfully suggest that yourself and your distinguished colleagues visit incognito, wearing the visage of poverty, some police stations in the villages adjoining Delhi. And I can tell you who wrote that adjective respectfully. Actually, this kind of orientation is very important and necessary for every judge who has to decide whether or not to grant a bail or an anticipatory bail, because many of them have actually no orientation of visiting a police station or visiting a police lockup to know what it is to be deprived of liberty, even for half an hour. One part of the letter talks about consent and forcefully makes the point that there's a clear difference between law and common sense as far as submission and the absence of resistance necessary to indicate consent. This is relevant for us given the judgment of the Delhi High Court in the Mahmood Farooqi case, which unfortunately was upheld by the Supreme Court of India. I just want to mention this. A single judge bench of the Delhi High Court set aside the trial court judgment convicting the accused inter alia on the ground that consent does not merely mean hesitation or reluctance or a no to any sexual advances, but has to be an affirmative one in clear terms, and that in the present case the appellant has not been communicated, or at least it is not known whether he has been communicated, that there was no consent of the prosecutrix. So there's been a lot of criticism of this judgment, and Mrinal Satish points out how this judgment ignores decades of rape law reform and catastrophically affects rape adjudication. Post December 2012, the Justice Verma Committee's recommendations have led to further changes in the criminal law. But contrary to what some of its recommendations read, the punishments imposed have been much harsher, including punishment by death, and which none of the groups of women who made submissions wanted. Now I come to the issue of sensitization of judges. I must now mention to you 2 or 3 instances, but before which I want to show the slides of the language the judges have used. And this is just a sampling. This is the High Court of Karnataka. Can you yeah.
I think
This is in a case of rape.
yeah, I can read.
Nothing is mentioned by the complainant as to why she went to her office at night, 11 p.m. She has also not objected to consuming drinks with the petitioner and allowing him to stay with her till morning. The explanation offered by the complainant that after the perpetration of the act she was tired and fell asleep is unbecoming of an Indian woman. That is not the way our women react when they are ravished. Then quickly he withdrew this. He considered it appropriate to expunge the last 4 lines. He's not revisiting the judgment. You can see how much the bias has affected the outcome of the case, but he's not touched the judgment. Only the last 4 lines have been expunged. Now, Delhi High Court. Our concern is 2 observations made by the learned judge, which read as under. Girls in such cases are mostly the age group of 19 to 24 years, thus mature enough to understand the consequences of their acts and not so snub, I mean I think smug must be, to get carried away with any representations of the boy. They voluntarily elope with their lovers to explore the greener pastures of bodily pleasure, and on return to their homes they conveniently fabricate the story of kidnap and rape in order to escape scolds and harsh treatment from parents. Girls are morally and socially bound not to indulge in sexual intercourse before a proper marriage, and if they do so, it will be to their peril, and they cannot be heard to cry later that it was rape. It is apparent, now this is the High Court saying, it is apparent that the 2 observations are sweeping and encompass females as a class, and the sermon by the learned judge is the feminine gender as a class. It is apparent that the remarks, which are general in nature, are not based on the evidence of the record. They appear to be the result of experience of the learned judge, which is transformed into his knowledge. It is apparent that the learned judge has imparted personal knowledge pertaining to females in their decision making. So the passage as a whole brings out the dilemma of the women in the Indian society, caught between her ambitions to choose a life partner and the pull of her patriarchal society. The woman is torn apart between her personal ambition and the patriarchal society. So placed, she has to be treated with sympathy and care and not made the object. Of course, this is again another problematic paragraph. So he then says we have to send him to the Judicial Academy for sensitization. Now the last, of course, is the Calcutta High Court. And this is as recent as 2024. This is actually, this 1, 2, 3, 4, 5 is in the judgment. It is a duty, obligation of every female adolescent to 1, protect the right to integrity of her body, protect her dignity and self-worth, thrive for overall development of her life, transcending gender barriers, control sexual urges. As in the eyes of society, she is the loser when she gives in to enjoy the sexual pleasure of hardly 2 minutes. Protect her right to autonomy of her body and her privacy. So fortunately, suo motu notice was taken of this by the Supreme Court of India. And this is what the judges said. In the appeal against conviction, the High Court was called upon to adjudicate only on the merits of the appeal and nothing else. But we find that the High Court has discussed so many issues which were irrelevant. Prima facie, we are of the view, while writing a judgment in such appeal, the judges are not expected to express their personal views. They are not expected to preach. We find that many parts, including are highly objectionable and completely unwarranted, are completely in violation of the rights of adolescents guaranteed under Article 21 of the Constitution of India. So it's so much about judicial attitudes. So Flavia Agnes, in one of the sessions in the Judicial Academy, shared this with all the judges and their jaws dropped. She said she was arguing a case of maintenance in one of the family courts in Bombay. And her client, since she was coming to the court, decided that she has to be dressed appropriately. And so picked up fake jewelry, somehow picked up a matching blouse for the sari and was standing behind Flavia. And when Flavia was vigorously arguing for enhancement and maintenance, the judge stopped her and said, "Is that your client?" She said, "Yes." And he looked at her again. He says, "She doesn't need enhancement and maintenance." Enhancement of maintenance. So Flavia said that thereafter she would always advise her clients not to dress up for court proceedings. I mean, all kinds of prejudices weigh with courts, and this is one. And these are the kinds of things that in Judicial Academy, increasingly, judges are, told about. Some of them, I mean, it has an impact. In some others, it doesn't. But one has to just hope that continued exposure to these kinds of, interactions would change their attitudes. I myself had an experience, and this is a bit amusing. This was a class of about 40 judges, and more than half of them were women. And I asked them to imagine themselves as the casting director of a film. And to make it easy for them, I said, this is a court scene. And you have an usher come in, and a very stern-looking judge come and sit on the chair. And his stenographer is very good-looking. And his usher, his court master is a person, who's around 30 years of age. And he has to examine a child witness, which is a victim of a sexual offense and brought in by the parent. Now I want you to cast people for these various roles. At the end of that exercise, they themselves were surprised that only 4 of the women, 4 of the entire class, who were all women, thought the judge could be a woman. Almost no one thought that the good-looking stenographer could be a man. So adjectives made a huge difference. The minute I used the adjective good-looking and I said stenographer, it had to be a woman. So, and the child who's a victim of sexual abuse had to be a girl child. So there are stereotypes that we try and bring out in judicial academies to tell judges that you have to fight these prejudices that come out very naturally. I don't know how many of you have heard of Justice D.K. Basu. He's no more now. But the judgment D.K. Basu versus Union of India is actually he being the petitioner. He was in legal aid movement in West Bengal, not the formal legal aid, but the informal legal aid. And he told us how he organized workshops for gender sensitization. And that would be a role play session. And this was about violence in a police station. And he said he cast the junior judicial officer as a inspector and the senior district judge as the suspect. And he said at one point he had to step in because the woman was taking her role very seriously. Now, last of the slides is going to be about the gender appropriate terms. What is amusing is what the Supreme Court has found, or the committee constituted the Supreme Court has found in judgments of various courts in India. The stereotype promoting language. So they actually have to write in the bracket incorrect, alternate language preferred. I'm not going to say anything, I just want you to read it. These are all actual language used in judgments, all right? The left. Now, what troubles me is what is written on the right as well. For the judge to pick up this whole sentence. But dutiful wife, faithful wife, good wife, obedient wife, all these are from language of the courts. Easy virtue.
Easy virtue. Woman.
Fallen woman. In the handbook. It's in society. Correct. But for the first time, they're acknowledging the necessity for correct language.
Yeah. That was also brought out.
Yes. But I don't know how far this is being discussed. Just handing around a booklet is really not going to. And they need to, I think, get feedback from how much of this is practical and appropriate.
Another research after that, how much of it is being actually applied?
Correct.
Women judges are not entirely immune to using sex.
No, not at all. So among the myths I thought will get demolished by a new committee will be that. The new jurisprudence on privacy has alerted courts to alter their ways of working. Anonymizing the names of litigants in matrimonial and custody cases in cases of sexual violence is but just beginning. Recognizing that gender is a matter of self-choice has meant that we rethink what constitutes a gender-based crime. Recently, a litigant who chose to be female approached our court, that is the Delhi High Court, complaining that the police would not register a case under Section 354 IPC against those who outraged her modesty in a male hostel. Does decriminalizing consensual sex require rape laws to be made gender neutral? So the debate is still out on this. The constitutional underpinnings of the jurisprudence of rights of these newer and emerging identities will necessarily require reworking the definitions of crime and criminality. There is also better awareness in the country about LGBTQ issues, something that the Committee on the Status of Women in India did not have occasion to deal with. Same-sex couples approaching courts for reliefs is not an unusual phenomenon anymore. In the Madras High Court, we've had another dimension of this problem. Women constables came to the High Court complaining that the trans woman was changing clothes in their room. So these are problems that courts have also to deal with. How judges may react is still another story. The point is, and I must share a rather humorous anecdote. So July 9th, 2009, July 2nd, 2009 is when Justice Shah and I delivered the NAS judgment. And from the reactions that were going on in the court, when we came back to the chamber, Justice Shah said, what do you think? I mean, will this have some impact? I said, what are you saying? It's going to have a huge impact. And so we went to the lunchroom in Delhi High Court. You go to the lunchroom, you sit around with other judges and share your lunch. And there was no reaction from any judge, which was very surprising. So after the second and third day, one of them said, in this court we have a new name for you and Justice Shah. I said, what? He said, Gaylords. The point is that if we were to speak of a study on similar lines as the Committee on Status of Women to be undertaking now, we might have to acknowledge that the social patterns of lived lives have undergone significant changes. The internet and social media have contributed in no small measure to this. Recently, I came across an interesting article titled Movement Judges by Brandon Hasbrook, an assistant professor at the Washington and Lee University of Law, where he argues that judges who bring more to the bench than empathy by raging against systemic injustices with an understanding of its burdens on real human judges can make judiciary a force for we the people. In that process, he talks of the need for movement judges to be aware of the present state of social movements, including the feminist movement, and I'm quoting him, from the suffragette movement in the early 1900s to the reproductive and workers' rights movements in the 1960s, feminism has swelled and attracted over the past century. Now, in the wake of the Me Too and the Time's Up movements, an unprecedented amount of discussion about women's rights issues is taking place. This new wave, known as the fourth wave feminism, is largely by design, where early feminist movements elevated white cisgender straight women. Modern feminism seeks to be more inclusive. Generally speaking, today's feminists work to create a world that supports women, including black women, indigenous women, poor women, immigrant women, disabled women, lesbian, queer, bisexual and trans women, and women of every religious and non-religious and atheist background, by eliminating shared injustices. The movement's focus areas include glass ceilings, rape culture, harassment, objectification, domestic violence, and reproductive rights, amongst other. Now I come to the last part of my talk. Here I ask, if one were to draw up an agenda or terms of reference for a body tasked with the exercise undertaken by the Committee on the Status of Women in India, what might that be? The terms of reference set for the CSWI in 1971 would of course continue, those 3 terms that I spoke about. This is because we need to constantly evaluate the progression or regression in the matter of emancipation of perhaps not just women, but each of the acknowledged minorities in the journey to achieving the constitutional goal of substantive equality. The composition of such a committee would no doubt have to reflect the various interest groups, which task itself might be a challenge. Also, what might such a committee find if it were to undertake the exercise on the same scale and breadth, and what myths might that committee demolish? For instance, while considering the place of a woman in the family, it might be confronted with the definitional constraints surrounding each of the terms, woman, family. This will have to be further modulated to account for other factors of disadvantage like caste, race, community, disability, and so on. Brandon Housebrook's observation that the fourth wave feminism is larger by design might have to be kept in view. In issues concerning the effectiveness of laws relating to marriage and divorce, maintenance and alimony, child custody, abduction, adoption, the committee would have to acknowledge the rights of single parents, of surrogate mothers, of gay couples. It might find that we have perhaps regressed in the matters of female feticide and amniocentesis. In dealing with the issue of women in religion, the committee will no doubt take note of the raging debate around the question of women's entries into religious sites and the practice of circumcision prevalent among the Dawoodi Bohra women. It may come across judicial confusion and undecidedness whether it is about banning hijabs in schools or recognizing marital rape, permitting same-sex marriages. It may in the process demolish a few myths. There can be a Dalit woman priest. Justice Chandru's judgment on this is worth reading, as much as there can be a woman bishop in a church in India. And yet, it might find untouchability continues unabated. Upper caste parents refusing to send their children to a public school where the free noon meals is cooked by a Dalit woman. The position of tribal women, which the judiciary was reluctant to address in Madhu Kishwar's case, may have to be taken up. The committee, we may recall, had made a strong pitch for a UCC, and Uttarakhand, the government has introduced a model which is, to say the least, the most abhorrent. So it might want to actually re-examine the whole issue and whether it should be pushed forth at all or not. In the area of health, the committee will note that some poor rural women still fall outside the net of state welfare when it comes to childbirth and rearing. We still have a number of maternal deaths, denial of ambulance services, and general access to tertiary health facilities, to creches for young children accompanying their mothers to work, or the precarious condition of children of women prisoners. Talking of women and property issues, the committee will find that despite the changes in laws, the position of women who are daughters in a Hindu family holding land has not dramatically improved. I came across Professor Veena Agarwal's recent study on that. There is still no proper recognition of the woman farmer. Again, for the younger people in the room, you must be acquainted with Professor Veena Agarwal's work in her own field. There's no proper recognition of the woman farmer or of women landless laborers to rights in land on which she works. In terms of women in politics, the committee might find the presence of larger number of women in panchayats encouraging, but the persistent attempts by the state to undermine their capacity to hold the posts of sarpanches through various devices of disqualification discouraging, not to speak of the phenomenon of sarpanch patis. It will note that the recent amendment providing for 33% reservation in parliament for women has left many dissatisfied. One scholar reminds us, today we are in a strange situation where everyone is in favor of reservations as if patriarchy has disappeared. She reminds us that it is imperative that the reservation policy for women recognizes the unequal forms that patriarchy takes in excluding women from public life. Also, it is equally important to guard against the idea that the mere presence of women in electoral politics will translate into women's equality and freedom. In similar vein, the committee might note that women are participating in larger numbers, sometimes after a long struggle, in the upper echelons of the armed forces, businesses, professions than before, while still struggling for parity of pay and terms and conditions, on par with their male counterparts. It's heartening to know for me personally that in the judicial services, a large number of women are entering judicial services, and their percentage might reach almost 70% in the next 5 years. And again, in the law universities, law schools, the number of girls enrolling is much higher than the boys. The committee may want to demolish the myth that the presence of women in the police and armed forces will ensure that there is no custodial violence, that there will be less corruption, that there will be less arbitrariness and greater sensitivity when it comes to women's issues, or that their holding politically powerful positions will ensure better democratic practices. It will note how women in construction work, in sex work, in domestic work, in unorganized work still face exploitation, threats to personal safety, security, discrimination, denial of subsistence wages. The denial of the Manrega wages for months on end is one example. Dalit women still undertake a large part of the sanitation work. Working women in the above settings, and even generally, face the toughest challenges during lockdowns, strife, or breakdown of law and order in caste and communal conflicts, or internal displacement brought about by a variety of man-made and natural disasters. While the committee will have to gather data on the operation of women-specific laws and assess their effectiveness, it may also have to address the issues women face among non-state actors, including political formations, private companies, civil society organizations, domestic and family settings, at home and abroad, and the barriers in their access to justice. This would include issues faced by families of the disappeared and those in detention camps, facing deportation on account of their failure to produce proof of citizenship. The disillusionment of victims of crime with the criminal justice system, where they face re-victimization and shaming, the tortuous process of legal procedure of trials and appeals, with slim prospect of witness protections, are issues that have to be dealt with. I'll now skip. There are no easy answers, but the search for them has to be a continuous effort, generation after generation, as the issues that humans have confronted through the ages not only refuse to disappear, but morph into more complex ones with every passing year. The committee never gave up hope and reminded us that there are multitudes of our fellow beings waiting to emancipate themselves into a life of freedom and dignity that the Constitution promises. Let the good work of the committee continue to serve as an inspiration for the present and next generations to build on. The process has to necessarily be inclusive, participative, and most important of all, transparent. So thank you. I think I've overshot my time. Thank you for your patience with me.
Thank you so much, and also giving a fresh agenda to the possibility of a committee, which is very remote thing. Anyway, I think Vasanti, you can have both opening and closing remarks.
Well, I think I would not like to add too much. We've got a lot of food for thought, and also, as Dr. Sharma has put it, that a fresh agenda for a new committee to be set up. This is a lot of us, I mean, for most of us, this is so, the idea itself sounds very exciting, and I'm sure we'll all be thinking about it. Thank you all for being here and making this a wonderful evening, and I would like to thank Justice Muralidhar, and of course Dr. Kumud Sharma, who's our Kumud Sharma, as she was saying, for this wonderful evening. We look forward to...
Do you want to have a small discussion? No.
Yes, that is for you to conduct.
No.
Yes. Having heard, I think I've raised a few questions.
How much? 10 minutes? Okay. If anyone has questions to Mr. Murali. Yeah, Veena?
Taking questions?
Yes, yes, please.
Yeah. So firstly, thank you for a really wonderful lecture. The whole history of the committee was something that
you've dug archives. It's just, certainly I didn't know. I think many of us didn't know. It's quite wonderful. And then all the other rich, bringing it up to date. So I had two questions. One relates to the committee itself. And in a way, it's both to you, Murli, and also to Kumud. That the 1970s were a period, was a very special period in terms of development debates, not just on gender. And there were three aspects that were happening at that point in time. One was the basic needs approach. ILO had, released the whole report on the importance of basic needs. The second was Amartya Sen's capability approach, where, of course, and he's also been arguing that we have to look at inequality within the poor, so the several layers of inequality. And the third was the huge debate on growth and inequality. So my first question is, to what extent did the committee, in a way, recognize, in a way the committee was a result of this, of the development debates, but also to what extent the committee itself conceptually recognized what was going on, not in the gender field, but in the more general field. The second is a very quick question on the last part of your lecture, Murli, which is, it's a question that, to what extent do you think, how well do our law schools teach the law? And I'm asking this, let me give you a very specific example. I've been researching Section 6 after the 2005 amendment. Under Section 6, both married and unmarried daughters are admitted as co-partners in joint family property. Now, in 2016, there was a Supreme Court judgment which said, and because the father had died, we can't actually recognize the woman as a co-partner, and we deny the rights. 2018, another Supreme Court judgment says, no, it's a birthright, and the father's living and death doesn't make a difference. 2 years later, 2018, there's another Supreme Court judgment which says, no, what matters is really if the father is alive or not, on September 2005, when it became law. And then in 2020, you have another 3-bench Supreme Court judgment which says, no, it's a right by birth. Now, by the time you reach the Supreme Court, you assume that they know the law. And certainly, I think the last judgment was correct. But what is it that makes them interpret something which seems so straightforward so incorrectly? And what is being taught in our law schools that enables them not to understand this?
I don't think we can blame law schools for that. See, the history of the Supreme Court does show that, there is differing opinion, but, this much is what the second question tells us is, the Indian Supreme Court is so different from other Supreme Courts in the world. I think barring Bangladesh, no other Supreme Court in the world has 17 benches and benches of 2 judges. So when you have such a wide, range of judges, you're bound to have, differing interpretations, and also who before them persuades them to see a provision a certain way. So actually you could even say that, some smart advocacy has brought this about. But the point remains is that we don't sit en banc. We should sit in larger benches so that these kind of conflict of decisions is minimized. And unless there's a serious disagreement with an earlier interpretation, it should not be relooked at in quick succession, like the one you're saying, from between 1916 and 20, you've had 4 judgments. I would consider this to be a kind of an aberration. But we're seeing even in other branches, whether it's arbitration or even criminal law, there's a quick turnover of judgments that's happening. Second factor I would attribute is to the sheer volume of cases. In no other Supreme Court in the world, a judge is having to deal with 60 cases in a single day. And this is an enormous load. So mentally, you're actually very, very tired. And I don't know in what frame of mind you address these issues, and, and what time you have to reflect and write a judgment. And having been on the bench for 17.5 years, I can tell you it's not much time at all. And it is very, very exhausting. It's not like manufacturing cars. So it's actually cerebral work. And these are human beings. So I think the likelihood of committing mistakes becomes higher when you have this heavy a caseload on your rosters. On the first, I think they did have task forces, they did have studies, but I don't know. Yeah, Kumud can tell us. Yeah,
Yeah.
because there was an
You want my
exclusive
answer?
task force on
Okay.
economics. Yeah.
Development debates.
I think, yes, I agree with you. There were a lot of work being done in various areas like basic needs, capability approach and other. Committee, when it was appointed, but after the terms of reference, whatever, they discussed that what is going to be their approach and the framework of inquiry for the committee's report. They decided that they are not going to look around for whatever has been going on, including they never wanted to have a look at the status of commission report which other countries have prepared, and wanted to have a kind of an independent inquiry into the way they decided to go about it. So it's like Esther Bozrah's book was also published before the committee submitted its report, but even that you do not find a reference to that in the committee's report. So I think it was you may say kind of a self-imposed kind of a restriction on them, or whatever they thought was the idea of how they are going to go about this inquiry. I think more emphasis was on whatever terms of reference were given to them by the government of India. They just went with that, instead of enlarging the scope of inquiry and incorporating many more issues as part of their inquiry.
Actually, should I add, in terms of what's happening with the present commissions and committees and all, taking over in September 73 and submitting a report by December 1974 of this magnitude is no mean task. That's remarkable.
No, it was constituted in 71.
No, but
But
reconstituted in 73.
the very fact that it did not function for a whole year.
Yeah, that's what.
I think there were internal problems, so sort of trying to solve
I
out
just
issues.
wanted to thank you for your wonderful lecture. Can I ask?
Yes, sure.
Yeah,
Excuse
Can
me.
you
Can
use this
she
mic?
just
I wanted to thank you for your excellent lecture. Now, I think there's been a significant decline of the level of discourse, particularly with regards to women's issues. And I won't go into details, but I just want to say that if you want to talk about women's participation in public life, simple thing like when you build a building and you have a fire exit and you have a front desk, etc. A simple thing like a room where women can leave their children to be safe when they're using that building for bona fide purposes. Even when I raised this in ISC, I was mocked at by the woman director and etc. Okay, this is my experience. As far as I'm a single parent and a proud single parent. Now, what about the structural changes? We can't leave our children. Where are we going to do? How are we going to enter workforce or public life? This can be easily part of our suggestions, and we don't make practical suggestions. What about the CUET forms? Why can't we put down mother's name? Why can't there be a column single parent? I have to put in. There's always father's name is mandatory even today. Now it's 2024. Father's qualifications are mandatory. The form will not move. It's online. You can't do anything. Why can't really we need a new commission? We need a new commission. We need to put down very, very practical suggestions. This is what I'm saying as a proud single mother. Thank you.
will you take another question? No, sorry, she has.
Please use the mic.
Please give the mic behind.
Sorry, excuse me. Merely that one of the reasons that something like the Ranganath Mishra Commission or some of these really long, protracted commissions have taken so long is because of the constant political interference. As I think Kumarji pointed out, that this was a very particular window when the report was written and actually placed in Parliament. You seem to not have had very much political opposition to it. In fact, it seems to have sailed, except, of course, in the appointment of the committee, which was full of bureaucrats and had no representation from the actual authors. So I think this is exceptional only because of that political window of opportunity.
Just one second. Indu, I can't hear you.
Indu,
Give
take the
the
Take the mic. Let
So
her,
I-
let her.
Yeah.
The minister put forward a resolution saying that the report will be placed in parliament so that it could not be hidden under the table. And you can imagine this is just pre-emergency. And Kumud will remember 20 years later when we had a discussion, many of the women, politicians, leaders, people like Mrinal Gore, Pramila Dandavate, they all participated in that discussion, and they said, we read it in jail. We read it in jail, we came out saying that when we come out, we will take up these issues. So it is a political moment, but it's also strategizing in times when, because this is just before the emergency. Sorry.
I'm sorry, I think, there is one question here. We have to close because another meeting is going to take place here.
We can discuss that in the.
I think the point, the question I just have is that there was a Committee on Status of Women report in 2015.
Yes. Formed.
And is there anyone who's familiar with that report and can tell us what, any comparative insights?
In
Okay.
fact,
Executive summary on
in fact, very shortly, there were two reports. One was in 2015,
five
then
volumes,
there was
five.
another one 40 years later, and its recommendations are all lying somewhere buried, I don't know where, because nothing has happened after the committee submitted its report.
You invite Renu to propose voting.
We should wind
Thank
it
you.
No, Renu is doing that. Vote of thanks.
Okay. Thank you for a very stimulating presentation and giving us an agenda for the future, and also a very entertaining presentation because you linked it up with issues that we can connect with. And thank you, Kumud, for setting the context for the CSWI, and to Vasanthi for persuading Dr. Muralidhar to give us the J.P.Naik lecture, and to all the staff of CWDS who have made this event possible. Thank you.
Please join us for tea outside.
Yes.